All right, let's dive into a legal puzzle that's over 150 years old. It's a fantastic story, really, about a horse, a deal gone wrong, and a court case that, believe it or not, has a huge impact on how you shop today. So here's our game plan. First, we're going to get the straight story, what actually happened with this horse. Then, I'm going to give you this simple 4-step tool that lawyers use to figure out pretty much any legal problem. After that, we'll use that tool to solve this case, and finally, we'll connect all the dots to your rights when you're shopping online. Let's bring this into the modern world for a second. Imagine you buy a brand new phone, and it comes with a 14-day return policy. On day 10, someone bumps into you, it drops, and the screen cracks. Totally not your fault. Can you still take it back for a full refund? It's a messy question, right? Well, the answer comes from this very old case. Okay, so let's set the scene. We're heading back to 1870s London. To really get why the court decided the way it did, we have to understand exactly what happened to bring these two guys to court in the first place.
So here's how it all went down, and it happened fast. A man named Head buys a horse. Now, he doesn't just buy any horse. He buys it because it was advertised as having hunted with some very famous, very prestigious hunting groups. The seller, Tattersall, even put a condition in the contract. If the horse isn't as described, you can return it. Simple. But here's the twist. Head finds out the seller wasn't telling the truth. But before he can take the horse back, it has an accident, and it's not Head's fault at all. So he tries to return the injured horse, and Tattersall says no way. And that's our conflict.
So how on earth does a judge untangle a mess like this? Well, lawyers have a secret weapon. It's a really simple but powerful framework for thinking logically about any legal issue. It's called IRAC, and once you get it, you'll see exactly how the judge came to their final decision. Now, don't let the acronym fool you. IRAC isn't some complicated legal theory. It's just a way to organize your thoughts. Think of it as a recipe with 4 steps that takes you from a confusing problem to a clear, logical answer.
And the recipe is super simple. First, you figure out the issue. What's the actual question we need to answer? Then you find the rule. What's the law that applies here? Next, you apply that rule to the facts of your situation. And finally, you come to a conclusion. Issue, rule, application, conclusion. That's it. Let's put it to work.
All right, we've got our toolkit. Let's pop open the hood on this case and use IRAC to solve the mystery of the injured horse. First up, the I in IRAC. Before we do anything else, we have to nail down the exact legal question that the court was trying to answer. So here's the million-dollar question the court had to grapple with. If a seller breaks a promise that was a key part of the deal, can the buyer still return the item for a full refund if it gets damaged after the sale, but through no fault of their own? You see, the timing of everything is absolutely crucial here.
Okay, on to the R, the rule. What legal principle, what piece of law could the court even look to for guidance on this?
The whole case really comes down to this one legal idea called a condition subsequent. Now, it sounds super formal, but you use this concept all the time. It's basically an out clause in a contract. That 30-day money-back guarantee you see everywhere, that's a condition subsequent. The deal is done unless you decide to return it within 30 days. That unless part, the right to undo the sale, that's the condition.
So, a condition subsequent, like our return policy, can actually end a contract that's already up and running. It's different from what's called a condition precedent, which is something that has to happen before the contract is even valid. Think about buying a house. The sale is often dependent on you getting a mortgage first. No mortgage, no contract. In our horse case, the right to return the horse because it wasn't as advertised, that was a classic condition subsequent. Now we get to the fun part, the A, application. This is where we take that legal rule and see how it fits with the facts of our horse sale. This is where the rubber meets the road. Here's how the court connected the dots. They said, look, that promise about the horse's hunting history wasn't just a minor detail. It was a fundamental condition of the sale. The moment Head found out that was a lie, the out clause, our condition subsequent, kicked in. He now had the right to return the horse. And the court decided that the unfortunate accident later on couldn't just magically erase that right. In essence, the risk and responsibility for the horse jumped back to the seller the second his promise was broken.
And all of that leads us, in a very logical way, to the final step in our IRAC journey, C for conclusion. So, the verdict, it was decisive. The seller's argument was pretty straightforward. You broke it, you bought it. You can't return damaged goods. But the court said, not so fast. They ruled that the right to get a refund wasn't about the horse's physical shape at the time of return. It was about the seller's original broken promise. Because that condition was breached, the whole contract could be unwound. Head got a full refund.
So a legal fight over a horse from 150 years ago. It's a great story. But so what? Why are we talking about it in this explainer today? Why does a case like Head vs. Tattersall still matter at all?
Well, because this single case carved out some major principles that are now baked into the DNA of contract law. It gave us a clear blueprint for how return policies and money-back guarantees actually work. It made it clear that if a seller breaks a key promise, the risk for accidental damage can actually shift back to them. This one ruling is a direct ancestor of the consumer rights you rely on every day. And it's a powerful reminder of why the terms and conditions, the fine print, are so incredibly important. One of the judges on the case, a guy named Baron Bramwell, just summed it up perfectly. He said, "The contract is annulled from the beginning." Just think about that for a second. The court didn't just cancel the deal from that point forward. They treated it as if the sale had never even happened at all. So the next time you're shopping online and you see that 30-day money-back guarantee, I want you to remember this story. The legal logic that protects you and lets you click that return item button was forged in a dispute over a lame horse way back in 1871. It kind of makes you wonder, what other invisible rules from the past are shaping our world right now?